So that was kind of an introduction to the capabilities of the software, excuse me. And so now I just want to go over the objectives of the webinar. The first objective is to give a very brief overview of the GEF IW-LEARN project and the Groundwater Community of Practice, which, as I mentioned before, is the entity hosting this webinar. It's also to inspire discussion and conversation on groundwater law. It's really an ongoing topic and a really upcoming and important discussion that we hope we can trigger more interest and kind of more circulation of opinions here. We also want to examine the relevance of groundwater law to the current and future GEF strategy on groundwater, especially since this is being convened under a GEF project. And we also want to continue these types of events. As I mentioned, this is the second webinar. We'll have a third one in 2014. And we also have an online discussion forum called the Global Groundwater Forum. You'll hear a little bit more about that later, where we can continue these types of exchanges. So we very much look forward to that. Just as a background, the Global Environmental, the Global Environment Facility is a financial mechanism that has over 182 member states and partnerships with all different types of organizations to address global environmental issues. It was originally started in 1991, but now is the largest public funder of projects about the environment. And it's an independent financial organization, although many people have heard of it in connection to the World Bank. And it provides grants for different focal areas, one of which is international waters. And that is the focal area under which the IW-LEARN project falls. And we just wanted to acknowledge that GEF has been around for over 20 years and has really contributed a lot to what we know about international waters today. So the IW-LEARN project started in 2011 and will conclude next year. And IW-LEARN is, in fact, an acronym. It stands for International Waters Learning Exchange and Resource Network. The goals of IW-LEARN are essentially to facilitate knowledge and information exchange and management about transboundary waters by generating a portfolio of lessons learned that have been the outcomes of projects. And a lot of this information is housed on IWLearn.net, which is the project's website. And it's a very unique initiative. I don't think it exists in any of the other, something comparable exists in the other GEF portfolio areas, although someone may correct me if I'm wrong. But it's also very nice in that this initiative has a strong focus on groundwater. So as part of this knowledge sharing, IW-LEARN established communities of practice, and Leib and Wegner define a community of practice as something when people who share a common interest and desire to learn and contribute to a community with their varieties of experience. So based on that definition, GEF has assembled kind of national experts, policymakers in various fields related to water and created the Groundwater Community of Practice. There's also a sister counterpart called the Surface Water Community of Practice, which is managed by IUCN, and essentially are structures around themes that are most relevant to their resource. And they also have some products, activities, forum discussions. And for the Groundwater Forum, there are kind of for the Groundwater COP, there are two places that it's being hosted. The products, so to speak, are on the Groundwater COP IWLearn.net, and the forum is the online conversation. And recently, a few months ago, the Global Groundwater Forum became the permanent home for the Groundwater Community of Practice. So this will extend beyond the the lifetime of the IWLEARN project. And it's a place for groundwater professionals or water professionals interested in groundwater to share ideas and best practices. And the site is housed by IGRAC, but co-moderated by IGRAC and UNESCO-IHP. And a very nice feature of the forum is that you can host kind of public discussion groups on specific topics, or people who may want to have private discussions about very specific groundwater issues online can also do that through our forum. A major outcome of the project, as I mentioned before, is a synthesis of knowledge, and that takes the form of the groundwater portfolio analysis, which will be published next year. And it essentially gives an overview of the different GEF IW projects and how they're implemented and kind of what the major achievements were and potential synergies that come from that. And one of those potential synergies is having people from the surface water-oriented projects and the groundwater-oriented projects talk to each other. And so as also under IWLearn, a series of groundwater integration dialogues were initiated. Two happened last year in Cape Town and Buenos Aires, and there will be a third at the beginning of next year. And essentially it's to share best practices from both sides and see where there are opportunities to promote conjunctive management of surface water and groundwater resources. Another big outcome of the IWLearn project was a series of videos and just documenting opinions from professionals about groundwater and its importance and ways to manage and assess it. So yes, I'd like to thank you for your attention. That kind of concludes the introduction. I know I went a little bit over time just to make sure that everyone was oriented, but I'm going to go ahead and pass the baton, if you will, to our first speaker, who is Professor Gabriel Eckstein, and he is with Texas A&M University School of Law, and he will be talking about the draft articles on the law of transboundary aquifers. So I will go ahead and
okay, you can hear me now?
Yes, we hear you.
Great. Okay, well, thank you for having me participate in this great webinar. What I'm going to do is talk a little bit about the draft articles on the law of transboundary aquifers, give everybody a background on their development, a little bit of the content of what's in the draft articles and their status right now before the UN General Assembly. Just as a background matter, I want to make sure that we have a good understanding that the volume of groundwater resources available worldwide are tremendous, many, many times greater than we have surface water resources. In fact, groundwater is the most extracted natural resource in the entire world, much more so than any kind of surface water extraction that we use for whether for its irrigation or personal use and so on. And so many people around the world rely on groundwater resources that it has become a critical resource that needs attention. And I emphasize that point because worldwide, we have so many transboundary aquifers, and in fact, we're discovering more transboundary aquifers as IGRAC continues its work. And in comparison, we have a scant amount of agreements and treaties that address these transboundary aquifers. As you can see, in the last 1,200 plus years, we've developed some 3,600 treaties for transboundary rivers and lakes. And to date, there really is only one management treaty for a transboundary aquifer, and that's the one for the Genovese aquifer. We have a handful of other agreements. Some of them are informal arrangements. And even though the number of transboundary aquifers far exceeds the number of transboundary rivers and lakes. So this is an area that is developing. It needs more development. And as we look back in terms of a legal background, the issue really didn't come to the fore until after World War II, and the main reason for that is because the technology wasn't there to exploit groundwater resources to the level that we do today. After World War II, when we really developed extensive drilling technology, stronger pumps, and so on, we started really exploiting these aquifers and also the transboundary aquifers. And so we started having a number of organizations globally start looking at these issues and trying to consider, well, what laws might apply to an aquifer that does cross a political frontier. We have a number of statements by the International Law Association, which is a unofficial professional membership association. So it doesn't have any kind of official international, at least UN status, but the material that they developed certainly has set the foundation for what has happened in more recent years. I just threw a number of other agreements that are relevant to transboundary aquifer law, even though they are not directly focused on that issue. These are the UNECE Watercourses Convention, the UN Watercourses Convention of 1997, and so on. These are all documents that are focused on surface waters, but do apply to some extent, and this is where we're not debating to what extent, but they do apply to some extent to transboundary aquifers. So after the development of the 1997 UN Watercourses Convention, the UN informed the UN International Law Commission that they should continue developing the law of transboundary waters, and look specifically to where the gaps need to be and where law needs to be developed. And so they appointed Ambassador Chusei Yamato of Japan as a special rapporteur for this topic in the International Law Commission, which I thought was pretty astute since Japan has no transboundary aquifers to speak of since they're an island nation. And so there would be any kind of perceived bias from the special rapporteur. Regardless, this was an effort that started around 2002. UNESCO was invited to support this effort, bring in experts, and I was honored to be on this experts group to advise the UNILC. In a matter of 6 years, which is really a phenomenally fast period of time, the UNILC, under the direction of Ambassador Yamato, produced 5 reports and addenda, and they actually produced draft articles on the law of transboundary aquifers. And I'm going to quickly review through those draft articles. And I'm only going to highlight a few of the provisions here just because of the lack of time. But I want to point out that the scope of these draft articles are, it applies to all transboundary freshwater aquifers. It's not focusing on any kind of saltwater issues, ocean water, and so on, but it applies to all aquifers related, regardless of whether they're related to surface waters or not. And in particular, if you look at B under Article 1, it applies to all activities that might have an impact on those aquifers. So it's not just the actual use of the aquifer, but it's activities that might impact those transboundary aquifers. I've pointed out just a number of the definitions presented in the draft articles, defining an aquifer as a permeable water-bearing geologic formation underlain by less permeable layer, and in the water contained in the saturated zone. So we're talking both about the matrix, the formation itself, as well as the water contained inside that matrix, which is a little bit of a conceptual issue, trying to figure out where exactly does the aquifer begin and end. Because we're talking about the saturated zone of the formation. And in an aquifer, as many of you know, there are unsaturated areas. So there are questions about how far does this, the draft articles extend. There's implications for recharge and discharge zones and so on. And this is something that must be taken into account as these draft articles are developed. One other point in the definition, the utilization, is not merely the use of the extraction of the water of the aquifer and aquifer matrix in terms of heat and mineral storage capacity, disposal of any substances, and so on. So it's I think a bit more expansive than simply using the waters of the vessel, so to speak. I want to highlight another particular article that has been in the draft article, that's put into the draft articles, that actually is one of a number of controversial points, and that's this one on sovereignty. This is a principle that was introduced into the draft articles after a fairly contentious series of discussions, and the question is whether the portion within a territorial area of a state is exclusive, or whether it is sort of internationally shared. This is a point I don't want to belabor too much, but just to point out that this is a topic that is still being debated and considered, and it's still a bit controversial. And my suspicion is this is one of the reasons why the draft articles are still in a draft article form, because these are issues that we still haven't quite wrapped our minds around and develop a consensus over how we want to manage and regulate transboundary aquifers. There are substantive principles and there are procedural principles that we find in the draft articles. I've highlighted some of the main substantive principles on this slide and the procedural ones on the next slide. I just want to briefly highlight them again. Equitable and reasonable utilization and no harm and cooperation are broadly known and used for surface water, and they have been introduced here for transboundary aquifers. Now, they have been modified to the extent that they apply to an aquifer, and the extent that an aquifer is a different type of water body than surface water. So issues of the slow flow of water in that aquifer is a factor. So questions of no harm, no significant harm, have been tweaked a bit to take those points into account. The other three provisions here that I want to highlight, these you do see environmental provisions in the surface water agreements, but I think it's particularly interesting that they were introduced here into this draft articles on transboundary aquifers, and this is another one of these questioned series of provisions. To what extent these represent the current state of the law versus a progressive development of the law. Moving to the next slide, just a number of the procedural principles, and I think these are fairly easily understood and accepted procedural principles: exchanging data, monitoring the different parameters of the aquifer, the characteristics, and notification of any planned activities that may affect a transboundary aquifer across the border. So real briefly, the status of the draft articles, they were introduced at the UN, to the UN General Assembly in December of 2008. The UN General Assembly is currently assessing them and reviewing them, and they are in particular looking at them in terms of the substance, which topics or which articles, draft articles, are controversial, which are non-controversial, which they might want to amend or modify. These are some of the issues that are being discussed at the UN level right now. And the other point is, what do we want the final form of these draft articles to be? Do we want an independent convention? Do we want some kind of declaration of principles or guidelines, and so on? So these are the issues being addressed, and I say they're being addressed right now. They were discussed in 2008, early 2009, when they were first introduced to the UN General Assembly. They were then tabled until 2011, and again brought up. And as you'll see in these slides, both discussions resulted in resolutions that commended the member states of the UN to take into account the provisions of these draft articles, to consider them, to evaluate them. Then again, the draft articles were tabled to this year, this October and November, and they have been debated again in the same vein that they were previously. Now, this time, and I know this is a draft resolution, it hasn't been finalized, but the language, there's a little bit of a language change. Instead of just taking into account the draft resolution suggests that the states, it commends the draft articles to be taken as guidance, which in my opinion takes them to a slightly higher level of relevance. But again, this is a draft document. I expect this will be finalized, or a resolution will be finalized in the next week or two. What it will contain, I still don't know, but this is the current status. It's being assessed, it's being evaluated, but presently the draft articles are still in draft form. Tentatively, it's expected that if this resolution goes into effect, it will be put on the agenda of the UN General Assembly again in 2015 for, again, further consideration and deliberation. So I thank you for your time, and this concludes my portion of the presentation.
Thank you very much for that great synopsis. It was very succinct because you fit a lot of issues and a lot of different dynamics that are going on with respect to the development of this particular piece of law into a very brief presentation. We appreciate that because that means we'll have some extra time for discussion later. So what I'm going to do is go ahead and turn over the baton, as it were, to Stefano Burchi, who is with the International Association for Water Law, among many other affiliations. Maybe he can briefly tell you about that as well. And just want to introduce his topic, which is the role of domestic groundwater law in terms of the interface with international groundwater law. So just one moment and you will see Stefano. Okay, great. Go ahead, Stefano. Thank you.
Now, let's see. How do I get the full screen?
You can press F5 on the keyboard.
F5, let's see. F5, no, nothing is happening. But anyway, because I'm not getting the full screen for the presentation, Kirstin.
Let's see if I can do it.
Yeah, I thought you would do it. You would control that.
Yeah.
But anyway, while this is being sorted out, so good afternoon to everybody. Thank you for coming to this webinar event on international groundwater law. My name is Kirstin Stefano Burchi. I'm the chairman of the Executive Council of the International Association for Water Law, which is a network of water law specialists, not only water law actually, we have a handful of engineers as well, and hydrologists and hydrogeologists. And I've worked, spent my entire career with the FAO, the Food and Agriculture Organization of the United Nations, in the legal office, in particular the Development Law Service, providing essentially advice to member countries of FAO on the issues of domestic water law, water legislation, and international water law as well. Now, I still can't see, but anyway. So now, what I'll be focusing on is the interplay, the interface between international groundwater law and domestic groundwater law. What Gabriel has illustrated are essentially developments in the works in progress towards the crystallization of principles and rules of interstate behavior, so behavior among sovereign states in regard and in relation to transboundary aquifers. Now, and he illustrated to us, the principles and some of the concepts which are embodied in the instrument which is now being considered at the present session of the General Assembly, these draft articles, the so-called draft articles on the law of transboundary aquifers. Now, eventually, when this instrument, if it becomes, a legally binding instrument, and maybe to some extent it is, because Gabriel alluded to this when he said, well, to what extent this instrument captures and essentially restates, puts down in writing law which is already there, customary law, and to what extent it presents a sort of some progressive development of this law, so sort of law in progress as it develops, as it were. But eventually, to the extent that this instrument captures customary law, so law which is already binding, or in future, it may become and it may translate into a legally binding instrument in the form of maybe a convention or a protocol to the UN Water Courses Convention, which is not yet in force anyway. Whatever, regardless, the principles and rules that operate at the international level in the dealings and in the relations among sovereign states eventually will have to translate into action on the ground. And this happens, and this is done through the intermediation, if you like, of the domestic legislation of individual states, of individual countries. And the translation of rules and principles, obligations and rights and obligations posited by international law and international groundwater law specifics, their translation into action on the ground at the domestic level of each individual member country of the global community, or of countries which are parties to a specific aquifer-specific treaty or agreement. This translation, if you like, this grounding of the principles down to at the domestic level of countries generates an interface, generates an interplay between the two planes, the two levels of law, international law and domestic law, which come into contact and should not be seen as a result as totally separate one from the other. This interface and this interaction is what I will address in this brief presentation. When it comes to, in particular, the law of international law of aquifers, so international groundwater law, if you like, or the law of transboundary aquifers, the management, aquifer management, engages domestic legislation concerning primarily two principal domains or realms. One is the domestic law of water resources, and the other one is land use law. Now, I will zoom in on water law in particular, and groundwater law, domestic groundwater law of countries. So I leave out of the scope of this presentation the land law and the land use legislation in particular of countries. And what I'll try to do is to essentially single out some precise norms, specific precise norms of interstate behavior that are posited in the draft articles on transboundary aquifers, which are or can be precise enough to lend themselves then to an analysis as from the lenses and from the standpoint of the domestic legislation of a particular country. In this case, I elected the Water Act of South Africa of 1998, and see how and to what extent the provisions of the Water Act of South Africa are conducive to compliance with the future obligations posited by the draft articles, and supportive of the provisions of the draft articles. Now, in particular, I find and I zeroed in on part 3 of the draft articles on the protection, preservation, and management of aquifers that were briefly illustrated by Gabriel. And to my mind, one finds in these provisions, one finds in this part of the draft articles, provisions which are precise enough to lend themselves to this kind of analysis from the standpoint of domestic legislation. Utilizing, now I'm really at some difficulty here. Kirstin?
Yes, I'm here.
Yes, can you rid me of this, of my own image and the panels, because I can only see one half of my presentation. I cannot see the rest.
Oh, okay. And you're still on the slide UNGA resolution part 3?
That's correct, yes, but I can only see one half of it.
Okay. Well, your first, hopefully we can fix that for you, but your first bullet is utilizing a recharging aquifer at the level that permits its effective functioning. Your second bullet is ensuring adequate quantities of recharge. And the third is preventing and minimizing detrimental impacts on the aquifer recharge and discharge process.
Okay, let's see what I have next. Preventing and controlling groundwater pollution, regular monitoring of aquifers, and can you read the rest? Aquifer utilization and aquifer management
planning.
We can. We have the full screen. No problem.
But I don't. So I'm having a very hard time, you know, following. And unfortunately,
reduce the zoom. You can zoom out your view.
But how do I do that?
At the bottom left,
yes.
You'll see the magnifying glasses with plus, minus.
Yes. So if I do it 50%, what happens? Okay, now it's better, yes. Okay, at least now I have the full thing in front of me, at least. I'm sorry for this.
No, it's okay.
There
are a lot of buttons.
Okay, there we are. So that's it, okay. So these are, you know, precise enough provisions that lend themselves then to an analysis from the standpoint of domestic legislation. In this particular case that I've taken up is that of South Africa. Now, without going, you know, into too much detail, let us take, for instance, that's it. That's it. For instance, if we take the for instance, the provision of the draft article, Article 10, draft Article 10, on the protection and preservation of ecosystems, aquifer states are directed to take appropriate measures to protect and preserve ecosystems within or dependent upon their transboundary aquifers or aquifer systems. Now, this provision is echoed, if you like, or maybe is helped by a particular provision in the Water Act of South Africa that provides for the reservation, for the reserve. In other words, for the reservation of water of suitable quality for the protection of aquatic ecosystems. There are some specific provisions in this statute that provide for setting aside, reserving water, the water of by implication, aquifers, for the protection of aquatic ecosystems. So to my mind, this provision is particularly helpful in fulfilling the purpose of Article 10 of the law of transboundary aquifers, insofar as it directs the states to take appropriate measures to protect and preserve ecosystems dependent upon transboundary aquifers. So if the groundwater of an aquifer is reserved for the purposes of the protection of aquatic ecosystems, this provision, to my reading, to my interpretation, to my mind, feeds into and supports this direction or this future obligation that you see enshrined in Article 10 of the draft articles. Now, another one is, let's see, where is the other one? Where is the other one? That's it. Another provision of relevance that you find in the Water Act of South Africa is the licensing scheme for the discharging of wastes into water bodies. Now, this kind of provision, this licensing scheme for wastewater discharges into freshwater bodies, to my mind and interpretation, is quite useful and helpful in complying with the provision of Article 12 in the draft articles, which speaks to the prevention, reduction, and control of pollution, where states are directed to reduce and control pollution of their transboundary aquifers or aquifer system. Well, surely enough, a domestic law system that that institutes licensing requirements or permit requirements for the discharge of wastes into freshwater bodies, including aquifers, surely goes in the direction of support for the provision of this particular instrument of these articles. Then another one is, there are several others. There are also provisions in the Water Act of South Africa that direct the users the licensees, so the holders of licenses to discharge wastes into freshwater bodies and to abstract water resources, to monitor their abstractions. In addition to a provision in the Water Act that mandates the government, in the person of the Minister for Water Resources, to survey, investigate, and monitor the water resources of the country. Well, surely this kind of domestic provisions are directly instrumental in ensuring compliance with the provisions of Article 13 of the draft articles on monitoring, where aquifer states are directed to monitor their transboundary aquifer or aquifer systems. So these kinds of provisions, if you read and if you look at a piece of domestic legislation like the South African Water Act, wearing the lenses off from the standpoint and the viewpoint of the obligations that stem from the draft articles, this instrument in the works, surely you can assess and gauge to what extent the provisions in the domestic law are consistent with, supportive of, and conducive to compliance with the rights and obligations posited by, in particular, the instrument that Gabriel illustrated. Now, in addition to that, then I will also point to a number of provisions, again, in the South African Water Act, which are directly related to, cognizant of, if you like, international obligations of South Africa, international water-related, of course, including groundwater-related obligations of South Africa, as these obligations are woven into and respect for compliance with the obligations, the international obligations of South Africa in the realm of freshwater resources, including groundwater, are directly woven into the fabric of the decision-making, domestic decision-making processes when it comes to allocating freshwater resources, including groundwater, among competing uses, and to, as we have seen, protecting freshwater resources, including groundwater, from pollution. Now, in the process of, and this is perhaps South Africa, this particular piece of legislation is the only one that I've seen using such explicit language that refers back to international obligations. You find in there a very, very explicit and a very direct, if you like, remand to the international obligations of this particular country, which in essence translates into a remand to the obligations that stem or will stem eventually from the instrument that Gabriel has illustrated. Now,
Stefano?
Yes?
Hi, it's Kirstin. I was just going to suggest maybe giving us a couple final points. I know we went a little long because of the technical difficulties, but I also, you presented a lot of interesting things.
I'm at
so
the
we
end.
want people to ask you interesting questions too.
I'm at the end. No,
Great,
what I would
perfect.
like to mention at the end by concluding that this is sort of what I've illustrated has perhaps value also as a methodology of analysis and of interpretation, because of this interface, of this interplay between the international plane and the domestic law plane, because you can apply it to gauging the level of support and responsiveness of domestic legislation to international obligations for groundwater in particular, stemming not only from the law, the draft articles on Transboundary aquifers, which is an instrument of global import, but also with respect to any aquifer-specific legal instrument, like the handful, there are a handful that are in effect now. Gabriel alluded to this, the Geneva aquifer, the Guarani aquifer is another example. There are only a handful, but you can use this methodology to gauge this interface between domestic and international, not only with respect to the law of transboundary aquifers of global import, but also with respect to any aquifer-specific treaty or agreements of the few that exist. Okay, I think I will stop here. Thank you for your attention, and please carry on. Thank you very much, Kirstin. I'm sorry for this mix-up with the anyway.
Oh, it's not a problem. Everyone was able to see and we were able to follow you, and that's the most important part. So thank you very much for another clear presentation with a lot of good information. And so now we're going to move to our final speaker, Ms. Annukka Lipponen, who's from the UNECE, or the United Nations Economic Commission for Europe, and she will be talking about their water convention. And so as soon as I get the video, we will start. Okay, great. Thank you, Annukka.
And IWLEARN for providing this opportunity to tell a bit about the UNECE Water Convention and about its application to groundwaters. So I'm Environmental Affairs Officer in the Secretariat of the Convention on the Protection and Use of Transboundary Watercourses and International Lakes, which is also known as the Helsinki Convention. And just some basics, it was signed in 1992 in Helsinki, and it entered into force in 1996. And it was initially negotiated as a pan-European framework agreement, but in 2003 the parties decided to amend it to make it accessible also to countries outside the pan-European region to become parties. The parties feeling that the experience from work under the convention was good and of value to other states also. And I should say that the Water Convention has served as model for most of the agreements signed on transboundary waters in the pan-European region since the 1990s, notably after the breakdown of the Soviet Union and the former Yugoslavia. And this amendment opening the convention entered into force in February this year. And once the last pending ratifications of the amendment are made, countries from other regions of the world could become parties. And the last meeting of the parties in November last year decided that the accession would be automatic once the country deposits its instrument of ratification in New York. This is the current status of ratification. 38 countries and the European Union as parties, and there are a few countries in accession at present time. The main obligations under the convention are these general principles of international water law, the two principles of protection of transboundary waters by preventing, controlling, and reducing transboundary impacts, or the no harm rule that Gabriel was mentioning. And then secondly, the reasonable and equitable use of transboundary waters. And in addition, as a kind of third pillar, if you like, is obligation to cooperate through entering into agreements and setting up joint institutions for the implementation. And these three pillars make up this overall objective of sustainability of the convention. And there are two categories of obligations, some for all parties, and the accession process involving a review of national legislation. This is also very useful for the national legislation, and of course the implementation also has beneficial impacts for the status of waters within the country. Then there's a set of obligations for riparian parties, or the states that the parties share waters with. And this being a framework agreement, it does not replace the basin agreements. On the contrary, they are mutually they're complementary. And these obligations include this obligation to enter into agreements, establish joint bodies. The convention is not very prescriptive about this, like what actual institutional arrangements are applied. It could be river commissions, could be aquifer commissions, bilateral commissions, and so on. And then there's the obligation to consult in the case of developments that may impact on stages of transboundary waters, and exchange of information. And the convention overall encourages and a broadening scope of information exchanged gradually. Then joint monitoring assessment is an important part of these obligations, involving harmonization or agreeing on common criteria for assessing the status of transboundary waters. And then finally, elaboration of joint objectives and action programs to achieve them. The convention applies to all transboundary waters. The definition employed is transboundary waters, meaning any surface or groundwaters which mark cross or are located on boundaries between two or more states. And it applies to groundwaters both in contact and not in interaction with surface waters. A number of activities have been carried out to support states in the implementation of the obligations and developing the transboundary cooperation on in management of groundwater, transboundary groundwaters. Among them are the guidelines on monitoring and assessment of transboundary groundwaters, and then we also supported a number of pilot projects for their application. Then in the early days, 1999, an inventory of transboundary groundwaters in Europe was compiled and published. And then later we carried out 2 regional assessments covering both surface waters and groundwaters in the pan-European region, extending from Western Europe to Central Asia. And in this, we had a very good cooperation with IGRAC. And if you're interested, this document, the second assessment, the latest regional assessment, is among the documents that were provided. So it gives an overview about the status of transboundary groundwaters. Some 200 groundwaters were inventoried, either aquifers or groundwater bodies that is the management unit in the European Union, and while somewhat fewer were then assessed actually, but it describes the status, the pressures on groundwaters, and then also the management measures taken, what are the tendencies, what's the level of cooperation, and so on. And in preparation of model provisions on transboundary groundwaters, a preliminary study was made of the application of the principles of the UNECE Convention to transboundary groundwater, and also a review study of groundwater and transboundary water agreements in Eastern Europe, Caucasus, and Central Asia was also carried out. So these model provisions that were adopted by the last meeting of the parties last year is a non-binding guidance, and this builds very heavily on the ILC draft articles on the law of transboundary aquifers. So therefore, the previous presenters gave me an easy job just very briefly referring to some of those provisions. Since the UNECE Convention refers to groundwater, so for consistency, even though a lot of the commentary refers to aquifers also, it's generally groundwaters the term that we apply. So the purpose of the model provisions is to that parties and non-parties could apply it when they maybe develop specific agreements on transboundary groundwaters, or if upon review they would like to complement an existing agreement with a protocol on transboundary groundwaters, for example. So they are really to be adapted to the particular case of cooperation and the setting with groundwater resources. And I'll just mention a few provisions from there, or say a few words very concisely. The first provision refers to the obligation to take all appropriate measures to prevent, control, and reduce transboundary impact. And this also provides for use of transboundary groundwaters in an equitable and reasonable manner, taking into account all the relevant factors. And actually the Bellagio model agreement and then the ILC draft articles elaborate on this, and these are referred to in the commentary, like the population dependent of the aquifer, alternative water sources available, and so on. Then provision 2 is closely linked to the previous. It refers to the sustainable use, and meaning that the management should be done in a way of maximizing the long-term benefits and sustaining the resource, preserving the dependent ecosystems, and mentions also the consideration of groundwater reserves, and also the stock, the non-renewable part. Then the provision number 3, it refers to the obligation to cooperate in the identification, delineation, and characterization of transboundary groundwaters jointly, and this describes a range of issues from quality to quantity, and mentions the use of common or harmonized standards and methodologies, and need to agree on the criteria and key parameters to be applied in the joint assessment, and also mentions monitoring network and the possibility or usefulness of developing maps such as groundwater vulnerability maps and use of conceptual models also. And then the provision 4, it refers to integrated management of surface and groundwaters. Overall, this is very strongly a part of this holistic approach is part of the convention, which also refers to recipient seas and refers to the catchment principle or as the level of management. And so this kind of in this provision is kind of about the progress towards conjunctive use, using in a integrated way the two resources. And provision number 5 focuses on prevention, control, and reduction of pollution. It mentions a range of measures as examples. It's not exhaustive, like definition of groundwater protection zones or regulation of land uses, defining groundwater quality objectives, and so on. And provision 6 is about exchange of information and data, and this makes reference to provision 3, where these types of information that are relevant are described in more detail. And then provision 7 is about establishment and implementation of joint or coordinated management plans to provide for example, water allocation, keeping track of abstraction volumes, application of pumping limitations, potentially in the case of groundwater reduction. And then provision number 8, it refers to the need to carry out environmental impact assessment in the case of planned activities that may have significant effect on transboundary groundwaters. And it also mentions in this context of notification and consultations. And in the case that all the riparian countries are parties to the ESPO Convention on the environmental impact assessment and transboundary context, which is another UNECE instrument, those provisions could be employed since it's a very comprehensive framework. And let's say abstractions are of course the most obvious case, and these are also singled out in the ESPO Convention from this domain, but also activities like mining, like hydraulic fracturing, etc., are mentioned there as potential activities that may have an impact. Then this provision also draws on another UNECE convention, the Aarhus Convention on access to information, public participation, and access to justice. And the Aarhus Convention is referred to for providing more details. And then finally, the 9th provision is about joint body or obligation to set up an institutional arrangement for implementation of the agreement. And just some concluding points. So overall, considering what Gabriel and Stefano also presented, a lot has happened in the past few years about the development of international water law concerning transboundary groundwaters, and it's really now about putting it into practice, and that's where the challenge is, the implementation, supporting the states to implement, and also to kind of try and make sure that groundwaters are considered in the broader framework of water management. That, for example, as many river basin commissions or bilateral commissions do not deal with groundwaters. Hopefully more taking into account of groundwaters could be added there. I think the history shows that the Helsinki Convention has an established platform already for some 40 parties and enjoys increasing participation from outside Pan-Europe also. Like for example, in the second assessment, we had bordering countries also participating: Afghanistan, Iran, Mongolia, and in the last meeting of the parties, I think some 18 or 19 countries from outside Pan-Europe participated as observers. So there's clearly interest. And I should note that all these guidelines that have been developed and these soft law instruments like the model provisions on transboundary groundwaters, but also on flooding, they can be applied by states in their particular settings. And I could mention that the institutional structure under the meeting of the parties has really adapted to the scope of work, that when there have been particular tasks specific to groundwaters, like the development of the guidelines, monitoring guidelines, and the pilot projects on groundwaters, there was a task force on groundwater working on this, or there was a group specifically on groundwaters. And now also for the development of the model provisions, a groundwater core group was established under the legal board to work on this task. And of course, this global opening hopefully will be soon possible for countries from other regions of the world to become parties. It's an opportunity, but of course a challenge also. Overall, we hope that the model provisions can be applied, since they also they build or somehow apply heavily this ILC draft articles experience and all that thinking. Hopefully, this can be a very practical support to countries for improving their transboundary cooperation. And strengthening capacity in the countries is really a priority task, and we need broad cooperation, like between international organizations, with the states, with the joint bodies that have already established themselves, but maybe their scope of work is more limited to surface waters. And of course, information and experience sharing is very important, and UNESCO-IHP and IGRAC and IW-LEARN, of course, play important roles in this, and we count on good cooperation in the future in this area. And that's all from me. Thanks very much for your attention.
Thank you, Annukka. So that was a wonderful presentation and a very succinct kind of summary of a lot of work that's gone on under the Water Convention with the UNECE. And so we are very grateful for that. Now what I'm going to do is kind of lead us in a question and answer. And what I've done is I've been scanning the questions, a lot of questions that have been coming in through the Q&A panel, which is great because that means we have very active participants, which we always want. And I'm hoping that I can go ahead and share mic and video with all of the presenters and just ask, I kind of created 4 questions that I think kind of capture some of what I've seen going on in the chat and also address some cross-cutting issues that I've heard all of you talk about, and then maybe each of you can jump in as you would like. So just give me a moment to put you all properly on video and also to unmute your microphones. In the meantime, the first question that I saw come up and that I know is pretty common is, okay, it seems like there are kind of three instruments moving around at this point. There's the UN Watercourses Convention, the draft articles, which were presented by Gabriel, and the UNECE Convention, which is presented by Annukka. And how are these instruments going to be managed? The UNECE Convention is enforced and it has a secretariat, so that's relatively clear, but how might that instrument interact with the draft articles or the Watercourses Convention if it comes into force? So if any of you have quick thoughts on that, I think that would be great, because it seems like a couple people in the audience are curious. Everyone is unmuted, so feel free.
This is Gabriel. I think that's going to be a fascinating question that is still hasn't been fully or adequately considered. Obviously, the UNECE process is much further along, since they already have the base convention, they have a secretariat, they're now integrating groundwater issues, while the 1997 UN Watercourses Convention is still not in force, and the draft articles obviously are merely draft articles. There will have to be some kind of harmonization at some point. However, the draft articles, I just want to highlight, and the UN Watercourses Convention, they're both framework documents. They're very general in content, and the UNECE Convention is quite a bit more specific, and was designed for the region of Europe, although now it's being expanded. So I think the harmonization shouldn't be too challenging in terms of local and regional agreements under the rubric of the framework. Where we will have some challenges is between the draft articles and the 1997 UN Watercourses Convention, because there is some overlap in those in the provisions there. But again, that's something that's still being developed and discussed, and we will have to wait and see.
Great, thank you for your answer. Stefano or Annukka, would you like to share any thoughts?
Well, so I tend to agree with Gabriel. There's a lot more precision to the kind of obligations that are in the UNECE Convention relative to the UN Watercourses Convention and the draft articles. So one might think, okay, well, the UNECE could be seen as a sort of an application, a more precise application of the principles and rules that are enshrined, in particular, in the UN Watercourses Convention, which have a global, import and an application in a specific context, I mean, the European context. Although I may anticipate there perhaps a problem. I mean, again, as Gabriel was alluding to, an issue of harmonization and reconciliation as the UNECE Water Convention moves out of Europe and more out of that region, in other words, that particular geographic region for which it was conceived of at the outset, and more countries may become parties to it and subscribe to it. So to me, there is an issue of harmonization there, perhaps not harmonization, but reconciliation, and sorting out perhaps where, which one, which convention, which instrument in particular, countries should abide by, if it is one. Although the UN Watercourses Convention is more general, more generic, still, there may be an issue of some harmonization I can see between that and the UNECE Convention.
Okay, great, thank you. Yes, that would be wonderful. Yes.
Well, just to say, first of all, that of course the ILC draft articles, we've we've taken them on in a way to the UNECE Water Convention now with the model provisions, even though it's a soft law instrument. It's non-binding, and it's for further application by the states. But of course, initially by nature, the UNECE Water Convention, it all along applied to both surface waters and groundwaters. The Helsinki Convention and the New York Convention, they are compatible. Absolutely, they are based on the same substantive principles: the equitable and reasonable utilization, the due diligence obligation of no harm, and they're also complementary. Like some aspects are be covered in more detail in one or the other. And actually, there are quite a few countries that have ratified both conventions, and so there is let's say ground in promoting the ratification of these two instruments as a package. Like it's let's say a powerful message from a country about adherence to the international water laws principle to ratify both instruments. But of course, it will take a while before the New York Convention is in a way operational, if you like, because there's no institutional structure foreseen in the instrument itself. So in the UNECE Water Convention, there's the institutional structure, the meeting of the parties, the working groups, the task forces, legal board, etc., and the secretariat. Plus, there's the work program defined every 3 years. Of course, the UNECE Water Convention can provide a platform for discussing, and also since it's open for observer states to come and attend the meetings, and many of the activities are already well attended by non-parties. This platform we can provide, but then in the end, it's up to the parties to these instruments to discuss and explore the options, and essentially the parties to the New York Convention will have to decide on what comes after the entry into force.
Great, thank you. That gave a really comprehensive picture of what, in my perception, is one of the kind of the biggest emerging issues about international groundwater law, which is how these mechanisms are going to interact. And also kind of stemming from Stefano's presentation, and again, a couple of other questions. I think a big topic is not just, okay, how will things interact at the international level, but then what does that actually mean for the states who adopt these laws, or even who may not necessarily adopt them, but may use them as guidance because they're an indication of what the broader international community wants. And so, yeah, what does it mean when someone tries to take some of these provisions and implement them at the national level? And one question I saw was just about assessment, in particular of transboundary resources. What does it mean to be party to an instrument, one of these instruments maybe? UNECE is a good example, and to then assess a transboundary resource. And once it's assessed, how do you actually go about creating maybe a monitoring program and things like that? So, and how much do these agreements say about the obligations of states in that regard? So, sorry, it's a very long question, but I'm trying to capture bits and pieces that I've seen. And if anyone has some thoughts on that, we would be grateful.
Annukka, don't you have Annukka alluded to this issue, I think, because the UNECE Convention through the Secretariat has, I think, from what I understand, has generated attention to the implementation requirements of the convention, and so I presume that the Secretariat, through its I don't know what it's, maybe some forms of technical assistance or what, but I'm speaking, so essentially I'm inviting perhaps a response from Annukka, because I think the UNECE is the instrument that has been more attentive to this particular issue of implementation, and how does the bundle of obligations which are signed on to by party states then reverberate and translate into action at the domestic level, which is not only through a revision or adoption or adaptation of domestic legislation, but it also through a number of additional measures. So I don't know if maybe Annukka has something to say to that.
Joint monitoring and assessment and identification and characterization is a very specific area, but maybe it's indeed good to talk about that. But of course, it's all subject to the particular setting, the nature of the resource, that the groundwater resources that the countries share, its extent, its vulnerability, the level of use, and of course it tends to sort of push the cooperation when the resource is heavily used, that there is more need then to coordinate and ensure the sustainability. But it's subject to dialogue. It's subject to agreement between the countries. Like, for example, of course, the scope of transboundary agreements is hugely variable if you look at what's in the pan-European region. Some are very specific. They're very focused on certain use. Some agreements are very broad, covering a range of uses, and also this institutional arrangement can be very different. Can be in Eastern Europe, this institution of plenipotentiaries is very common. There's not necessarily or in most cases it's just it's regular meetings, be it once a year, for example. But really, the countries need to agree on what are the uses, what's the knowledge of the status of the resource, what are their monitoring arrangements in place. It needs to build on the national systems that are in place, and it's important to identify the most important parameters, for example, to start with, to get an idea about the status, be it groundwater levels to start with, or the nutrient concentrations. It's good to improve gradually over time, kind of go step by step, and not maybe start too ambitiously. The main obligations are our cooperation through establishing an agreement, setting up a joint body, meeting regularly. This is where it starts from. Maybe I allow for others to elaborate. Maybe, I don't know if Gabriel or Stefano wants to add something to this.
Well, Gabriel, I don't know if you feel, but there's obviously whenever countries embark on on a joint course of action or coordinated course of action and sign an agreement or a treaty, out of which come certain obligations, rights, but also obligations and duties and all that. Presumably, I mean, the concern, it's quite a legitimate concern on the part of signatory or party countries, party states, to make sure that they have the capacity and the capability to deliver on the obligations which they have undertaken. One can think, okay, well, but you know, this work, this capability or capacity assessment should perhaps be done at the outset and in preparation for maybe signing of a treaty or negotiating a treaty and all of that. And yet, you know, it is an important adjunct, and it's an important component of, if you like, the whole host of obligations and you know, signing on to obligations through a treaty, an agreement, or accession to an instrument like the UNECE instrument. So I would have thought that perhaps some kind of a assistance capability or technical assistance or whatever, like in the nature, I think something along these lines is available through the UNECE Secretariat to the Convention, if I'm not wrong. This is what I was thinking and alluding to, Annukka, that is there such a service available from the Convention Secretariat to states which contemplate, which are parties or contemplate becoming parties to the Convention, to help and assist, you know, gauge their capacity to deliver on the obligations of the Convention, or to build that capacity, to upgrade that capacity to deliver on the obligations that stem from the Convention? Is something along these lines available from the Convention Secretariat?
Absolutely. Like this support to implementation is the most important area of work under the Convention, and the kinds of support that is provided is support to negotiating agreements. Let's say also countries who are interested in ratifying Secretariat through Secretariat assistance is available. Projects can be set up to support setting up joint monitoring or go through negotiations to prepare an agreement and set up a joint body. Then now there's also a new structure under the meeting of the parties. There's implementation committee where specific issues can be brought by parties. They have an issue with a riparian party, a neighboring country, and in some cases, subject to agreement, this could involve a non-party also. But this is a new mechanism. But let's say this more general kind of assistance in applying the guidelines through pilot projects, for example. This is what we do very much, yes. And now, let's say the scope of areas of work under the Convention, the current work program, they include quantification of benefits of transboundary cooperation. There's support to like essentially reconciling different uses. This nexus between energy, agriculture, water, and ecosystems, and climate adaptation to climate change in transboundary basins is also a big area of work. So there's quite a range.
Thank you. And I'm actually happy that you brought up the issue of capacity, Stefano, because that was going to be my next question. But I think we're running out of time. And so what I want to do, instead of going into capacity, which is a very big issue, is maybe ask each of the three of you to give 3 sentences, if possible, about a story of international groundwater law. One of the participants asked about the role of international groundwater law in transboundary aquifers shared between U.S. and Mexico. Maybe, Gabriel, you could share a few words on that. And then, Stefano, I think you have experience with the Northwest Saharan aquifer, so maybe you could talk a little bit about that. And then, Annukka, if you could just pick a case that inspires you from the UNECE. If you could just summarize how you see groundwater law in action in those cases as quickly as possible, that would be great. And I think it would be a nice way to close. So whoever, maybe we can start with Gabriel since we had a specific question about the U.S.-Mexico TBAs.
Sure, and I responded to that in the Q&A. So if others want to look at my response, maybe it's unfortunate that you start with me because I'm very pessimistic about the U.S.-Mexico border and transboundary groundwater law. There is no law on the border. There is no treaty, and the governments, the federal governments of both nations, don't seem to be very interested in developing. At least at the federal level, it doesn't seem to be a priority. It certainly is a priority on the local level. And so the article, I have an article I just published, which I put a link in my response in the Q&A to that article, how to try to develop local arrangements when the federal governments don't have a particular interest in any kind of cooperation over that issue. So unfortunately, on the U.S.-Mexico border, I'm not sure that that's a model to look at.
Yes, thank you for that. Those insights, we appreciate that. Maybe Stefano, you could go ahead and talk about your experience with Northwest.
Maybe inject a bride of you.
Sure.
Obvious. That one, the Northwestern Sahara Aquifer system, is huge. It's shared by Algeria, Libya, and Tunisia. It is quite vital to all three countries. And there was, at the outset, when I got involved in it, through the FAO, of course, there was little appreciation of the, how could I say, of the value of the need for a legally binding instrument or a treaty, a treaty as such, as we know from, other examples. But the building upon a long history of cooperation on the ground, either bilateral, mostly bilateral, in the bilateral level. Building on that cooperation, there emerged, and we capitalized on a strong vision for what they call a basin, or if you like, an aquifer conscience and a conscience de bassin. So there was a strong feeling that they had, the three countries shared this important resource, that it was common to them. So there was an intense perception of sharing something, of great value to all three countries. And then through there was a champion, somebody in particular, a quite charismatic figure actually in Tunisia in particular, who carried this idea forward all the way through to the actual establishment of a permanent mechanism, institution for cooperation among the three countries. And building on that, and once that sort of hatched, it became possible to translate that sentiment, if you like, or that perception into a legally binding instrument, an agreement that essentially created actually and laid the foundations for this cooperation institution, for this cooperation mechanism to be born and to start functioning and to begin functioning. And this mechanism has been in place and has been live and kicking now for a number of years, 5 years, I believe now, and is essentially predicating, cooperation among the three countries on firmer grounds than before.
Okay, great. Thank you for that summary. And Annukka, will you wrap up for us with the last example?
Yes, I just mentioned briefly a couple of examples. Thanks. Had there been more time to specifically look for information, would have been more specific. But at least one case where, let's say, there's encouraging history of stabilization of status of an aquifer is an aquifer shared between Flanders and France. This is a carboniferous aquifer where there was a consistent, continuous decrease of the groundwater level And then the countries agreed on limitations to abstractions, and the status stabilized. And another case from the region that I'd like to bring up is the Danube Protection Commission, which is modeled essentially on the UNECE convention, and this ICPDR is one of the few joint bodies at basin level that also addresses groundwaters. They have a working group on groundwaters, and they've carried out this exercise of identifying transboundary groundwaters of basin-wide significance, and they've done this kind of joint characterization for this larger groundwater resources that are transboundary, and so this kind of gives to me a face that groundwater issues can also be gradually integrated into this broader framework of water resources management.
Okay, great. It's nice to end on a positive note, and also, yes, just wanted to say a very quick, maybe too quick, thank you to our three presenters. You did a wonderful job giving an overview of all the different initiatives that are going on, and really appreciate your time. And also, we received quite a few questions from the attendees about how they might be able to access the documents that were shown here. So there's one we talked about at the beginning, which is hitting Control-T. That will allow you to see some of kind of the more supplementary resources that were made available. But now, if you look at your screen, it'll show you a quick way to make sure that you leave the event properly. And when you leave this way, you'll have the option to save all the event files. So each of the tabs you see open at the top will save, the documents will save to your computer. So if you go to your file and you click Leave Event, then, oh, I guess it's only one page. Yeah, if you click Leave Event, a screen will pop up and it will say, would you like to save documents? Click Yes, and then you will have them. And the recording of this webinar will also be available in the next few days on both the IGRAC forum and the IWLearn websites. And maybe I'll put those websites and links in the chat bar very quickly. But here is the IWLearn website. Oh, here we go. So you see it's the IWLearn Community of Practice. And here's the webinars page. And it will also be available at the IGRAC Groundwater Forum at the webinars page on the left. So I think that concludes our event for today. Thank you everyone for coming. Thank you speakers for a very interesting and thought-provoking discussion. And thank you to our hidden technical genius, Fred from UNESCO, who is here making sure everything went smoothly. So have a great evening or day, everyone, depending on where you're located, and hope to see you at the next webinar.